Welcome to EU Privacy for All, Session 44 on GDPR, Article 52, Independence of the Supervisory Authority. Article 47 was finally renumbered Article 52 on the independence of supervisory authorities. This article lays down that each supervisory authority shall act with complete independence. Its members shall remain free from external influence and shall neither seek nor take instructions from anybody. Members of those authorities shall refrain from any action incompatible with their duties. Each member state shall ensure that each supervisory authority is provided with the human, technical and financial resources, premises and infrastructure necessary for the effective performance of its tasks and exercise of its powers. Those member states shall also ensure that each supervisory authority chooses and has its own staff. And finally ensure that each supervisory authority is subject to financial control which does not affect its independence and that it has separate public annual budgets which may be part of the overall state or national budget. In Recital 121, it is reminded that each member state should in particular provide provisions in order to have members of supervisory authorities appointed by means of a transparent procedure, either by the parliament, government, or the head of state of the member state, on the basis of a proposal coming from the government, a member of the government, the parliament, or a chamber of the parliament, or by an independent body entrusted under member state law. There are other key provisions in the GDPR regarding the complete independence of supervisory authorities, such as Recital 117, raising the fact that it is an essential component of the protection of natural persons, Recital 118, referring to the fact that such an independence should not mean that the supervisory authorities cannot be subject to control or monitoring mechanism regarding their financial expenditure or to judicial review, a reference to EDPB, the European Data Protection Board, independence regarding the fact that performance of its tasks or exercise of its powers shall be based on the fact that its members do not seek or take instructions from anybody, and Article 54(1)d, referring to the duration of the term of the members of each supervisory authority, that should not be less than 4 years in order to ensure such an independence. Directive 95/46 refers in Article 28 to the fact that the supervisory authorities are to act with complete independence. In the end of the article, in paragraph 7, it is also stressed that member states shall provide that the members and staff of the supervisory authorities, even after their employment has ended, are to be subject to a duty of professional secrecy. What should accountable data controllers and processors get prepared for? First, they should identify and exchange with the one or more independent public authorities that are responsible for the monitoring of the application of the GDPR. They should pay attention to the definition of what national supervisory independence means, according to national laws, but also to these authorities' interpretation and their EU counterparts, as framed by the EUCG and national courts, in order to protect the fundamental rights and freedoms of EU citizens regarding the processing of their personal data. They should bear in mind that such independence goes along with national authorities cooperating with each other, nationally but also at an EU level, and with the EU Commission. Supervisory authorities should remain free from external influence, whether direct or indirect, and not take instructions from anybody. Members of the supervisory authorities concerned will refrain from any action incompatible with their duties and will not, during their term of office, engage with any incompatible occupation, whether gainful or not. So the question now relates to the fact that the independence of each national supervisory authority will be evolving after EU-CG Schrems ruling with regard to the GDPR, EU consistent regulation and enforcement.